I want to start with a moment, a specific moment. It's the late 2000s. I'm sitting across from a federal investigator who has decided, before asking me a single question, that I'm a criminal. They have a file, they have a theory, they have a cooperating witness who has already signed a deal to tell them exactly what they need to hear. What they do not have is the truth. The truth is that my tax attorney, a man named Christopher Rush, had been opening a Swiss bank account in my name without my knowledge and without my authorization. He had forged my signature on documents I had never seen. He had used those accounts in ways I knew nothing about, and when the government came for him, he had a choice: face his own charges or become a paid government informant and hand them a bigger target. He chose to hand them me. I want to be clear about something. I am not an attorney. I am not here to give legal advice. I am the CEO of the U.S. Observer, an investigative newspaper and advocacy organization that was founded in 1991. I have over 2 decades helping people who are wrongfully accused fight back with documented truth and First Amendment protected journalism. But the reason I speak to what you're going through is, if you're going through it, the reason this works is not abstract to me, is that I lived 15 years as a federal defendant. This is how it started. Christopher Rush was my tax attorney. In the world of international business and financial planning in the early 2000s, he came with credentials and referrals. He handled a complex work. I trusted him. What I did not know was that Chris Rush was opening Swiss bank accounts using my name. He had forged my signature on foreign financial disclosures. He had structured transactions I never authorized in accounts I did not know existed under a name I did not give permission to use. When the government scrutiny eventually found Rush, he made a calculation. He became a cooperating witness for the Department of Justice. That designation comes with significant benefits: reduced charges, leniency, protection. In exchange, cooperating witnesses provide information, testimony, and in some cases, they help shape the story that the government needs to build a case against someone else. In my case, that someone else was me, the evidence that they already had. Here's the fact that I still return to, even now. Before any charges were brought against me, the Internal Revenue Service had already issued me a refund of approximately $500,000. That refund was not a clerical error. It was the IRS formal conclusion that my taxes were accurate and that I owed nothing and that they owed me money. That document existed. It was in the government's possession. The Department of Justice prosecuted me anyway. I'm not speculating about prosecutorial motive. I'm telling you what happened. The agency that audits the taxes said that my taxes were clean. The agency that prosecutes crimes looked at the same situation and decided I was a criminal. 6 felony charges, a potential sentence that, if every count had been applied consecutively, could have put me away for 30 years. I was not a young man when this began. I had a family. I had a business. I'd spent years building. I had a reputation in my community. And I had government that had decided it was his next prosecution, regardless of what the facts show. What Rush gave them, a cooperating witness in a federal case, is not a neutral party. They are a party who has agreed to provide information, testimony, or both in exchange for consideration on their own charges. The value of their cooperation is measured in large part by the significance of the case they helped to build. The bigger the target, the better the deal. I am not speculating about Rush's motivations. I'm describing the structure of the arrangement that the government offers. When your freedom depends upon usefulness of what you give prosecutors, the incentive is not to be scrupulously accurate. The incentive is to be useful. Rush had knowledge of the accounts. He had knowledge of the documentation because he created it. He was positioned to explain the transaction he had executed in my name, without my authorization, in a way that made me look like the architect of the scheme rather than the person whose name had been borrowed without consent. And the IRS refund, the $500,000 documented conclusion that my taxes were accurate, remained in the file, acknowledged and set aside. The weight of it, the people who have not faced federal prosecution sometimes struggle to understand the scale of what it does to a life. The legal costs alone are staggering. Federal criminal defense at a level required for contested multi-count felony case is not a small expense. It runs into the hundreds of thousands or millions. You spend down savings, you liquidate assets, you watch the financial foundation you built over decades go into attorney's fees, expert witnesses, and appeals. And while that's happening, the case hangs over everything, every relationship, every business decision, every morning you wake up knowing that federal prosecutors are still working to put you in prison. I want to say something about my father-in-law, Colonel John Lee. He was a man I respected deeply. He spent his life in service. He was precise, disciplined, and did not say the things he did not mean. Colonel Lee was dying when he pulled me close and said this: "Fight them, Mike. Don't you dare give up." He was not talking about strategy. He was not giving legal advice. He was telling me something he understood at the deepest level a man can understand it, that there are moments in life when the only thing that matters is whether you are willing to stand up. I kept that with me through every year of the prosecution, through every motion that failed, every setback that came, through the moments when the math of the thing, the financial reality, the toll on my family made quitting feel like a reasonable choice. I did not quit. What they built. Over 15 years, the Department of Justice constructed a prosecution built substantially on testimony of Chris Rush, a man who had forged my signature, opened accounts in my name without authorization, and then agreed to tell the government whatever it needed to in exchange for favorable treatment on his own charges. That is the foundation of felony counts that could have taken the rest of my life. I tell you this not to make you angry on my behalf. I'm past the anger. I tell you this because what happened to me is not a unique story. It's a pattern. It's cooperating witness with something to gain, a prosecution theory that requires only selective use of the available evidence, a defendant who, at any point in time during 15 years of financial and personal exhaustion, could have been offered a plea deal that would have ended the fight. I never took the deal. And in January of 2024, 8 jurors heard everything the government had built, deliberated 4 hours, and came back with a unanimous verdict. But that is the next video, because what I want you to sit through tonight is not how it ended. It's what it took to get there and what the system looked like from the inside. If you're facing something like this right now, I want you to know something the system is designed to make you feel alone, to make you feel like the only rational move is to stop fighting. I'm here to tell you that that is not true. And I am going to keep telling you the truth about how this works for as long as this channel is running. In part 2, I'm going to walk you through what 15 years of fighting the federal government actually looks like, the tactics they used, the moments that nearly broke through, and what finally changed the outcome. If you're not subscribed, do that now. You will not want to miss this. I am Michael Quiel. I will see you in the next one.